Good afternoon, everyone, and welcome to this Davies Collison Cave Law Update. We've got three sessions for you this afternoon. The first one relates to the continued operation of the courts in Australia. The second session relates to issues arising in contracts from companies in financial distress and issues arising out of IP licences, including licences for COVID-related technologies and compulsory licensing in Australia, a topic that I think is going to become more and more relevant as the year progresses. And the last topic relates to innovation during the COVID-19 disruption. Talking in the first session will be my colleague Paul Dewar and I, in the second Rodney DeBoos, and in the third Jacqueline Simkin. So I thought we might kick things off first with the short seminar on the continued operation of the courts in Australia.
Thanks very much, Chris. So this seminar is on virtual hearings, which is a pretty hotly debated topic at the moment. The courts have formed the view that in the interest of justice, the starting point is that hearings should proceed, which means that those hearings, by necessity, are largely virtual at the moment, with certain exceptions that we'll discuss. The courts will adopt that position as the starting point unless they're satisfied that it's likely that one of the parties would suffer material prejudice as a result of proceeding in that manner, or if there's an unacceptable risk of a mistrial if the trial were to proceed. So in considering any application to adjourn, the court really is weighing up the interests of both parties and weighing up the interest of having the matters proceed and being determined in a timely and efficient fashion against any potential injustice to the parties. But it's fair to say, and Chris and I will discuss this in more detail, that the court's starting point really is the presumption that things have to go ahead, and the parties will need to explain and provide, good and compelling reasons why the hearings won't go ahead virtually if they can't go ahead physically.
Thanks, Paul. It is true to say that the courts have adjusted very quickly. At the beginning of March, the Federal Court sent out a communication indicating that all hearings were going to be immediately vacated. And then very quickly, the courts have adapted to the current situation and have been able to conduct hearings using a variety of different audio-visual technologies to allow the wheels of justice to continue to turn. It's also been interesting that the courts have been able to allow non-participants in litigation, so the casual observer, to observe matters. And in fact, I suspect that that's meant that it's been easier for the public to observe court hearings and trials, which is a good thing, and I suspect that's something that's going to continue. We've included in the slide pack some of the specific arrangements made by the various courts, but it is fair to say that the Australian courts are open for business and adapting very quickly. I just thought I'd put up some slides there about the formal position of the Victorian courts. The Supreme Court is conducting virtual hearings via WebEx, Skype and Zoom. I should say that these hearings are civil hearings. As I understand it, there has been one county court criminal trial, but criminal trials have stopped, and the criminal trial that has occurred so far has been judge alone, and there's also been an explosion of bail applications, obviously. So the courts have adapted for civil matters, certainly very quickly. The Magistrates Court does remain open, but most non-urgent matters are being adjourned to reduce the number of people in buildings, and VCAT hearings are going on remotely, and where possible matters are being determined on the papers. But I understand that there are some quite lengthy hearings that are going to be taking place and are taking place in all of those tribunals, including a very significant 5-week trial that has started in the Supreme Court, civil trial started in the Supreme Court on Monday.
Yes, so unsurprisingly, the position in New South Wales is very similar. On the slide there, you'll see the position with respect to certain of the courts. That's the current position, obviously, and given how quickly things are changing, As Chris said, the courts are reacting to those changes very quickly as well. As you'll see from the slides, it's a mixture of in-person and remote attendances, and sometimes that can be at the same time. So there's certain aspects of litigation which are considered to be particularly important. Cross-examination, for example, where ideally you would have the witness in the courtroom and the judge could view the witness and form an opinion in relation to credit and that sort of thing. So there are circumstances where you might just have a witness and the judge and the cross-examiner in the court, and other people would be attending remotely. That is not ideal, obviously, but in circumstances where you can get some of the benefit of in-person attendance without the detriment of having too many people in the courtroom, then that's an option which is sometimes used. But generally speaking, where possible, the courts are trying to determine hearings via video conferencing and, as Chris said on the papers, the court adapted to this technology very quickly. And because it's now been in practice for several months, it's pretty streamlined now. So it tends to go off without a hitch. There's the usual taking of attendances, and the hearing system works in the same way, except it's done virtually, and all of the various aspects of the system, the video conferencing and the sound are all thoroughly checked. That doesn't mean that things don't happen and there aren't delays, but the court's very understanding of that at the moment, and sometimes the courts will start earlier or sit later to make up for any sort of problems with the telecommunication systems. The courts have put up pretty detailed guides in relation to that. So the parties are very well informed, and it's, in my experience and in Chris's as well, I believe it's been pretty seamless. Yep. Yeah, so here's a comment from Justice Param in relation to the general position. It's a pretty strong comment. And it does sum up the attitude, certainly, that the federal court's been taken in relation to matters, which is that it's not quite sure how long this is going to go on for, and it can't be in the interest of justice to allow the case log to back up things. Things have to continue.
Yeah, the question might be asked why the court's determined to proceed with hearings, and as this goes on longer and longer, I think it's fairly clear that first of all, justice wouldn't get done. We have to try and continue to move things along. There would be an enormous backlog which would take years to clear if steps weren't taken to deal with things now. And finally, as this has gone on, the courts and the practitioners have got better and better in dealing with it and coping with it, and have found ways to make it work fairly efficiently. And the profession's been fairly collegiate in sharing information about how things might work and might work well. And the courts have got to a stage where they're refusing to adjourn virtual hearings unless doing so would be inconsistent with the overarching purpose, which is to facilitate the just resolution of disputes according to law and quickly, inexpensively and as efficiently as possible. So if it clearly would cause one party prejudice, then the court will agree to an adjournment, but there have been plenty of examples where one side's asked for an adjournment and the judges said, no, we'll press on and we'll try and find alternative solutions and be clever about how we deal with it. If I can give maybe a couple of examples of how the court is adapting, particularly the federal court, one in relation to mediation and one in relation to hearings. Early in this, in sort of mid-February, I had a mediation. Our client was based, in fact, both parties' clients were based overseas, and the mediation took place in Teams, using Microsoft Teams, and it was quite an effective way of dealing with it. There was a central room set up where all the parties and all the clients were present with the mediator. Then each side had its own meeting room, and then other rooms were created as time went on to allow the clients just to talk to one another, or the lawyers just to talk to one another. And the mediator, who was a federal court mediator, was able to move between the rooms. And that worked very efficiently. We all had to, I asked what attire we all wear. So we were in suits, sitting at home, conducting this mediation, and it really worked quite efficiently. And I think that in the future, particularly with overseas clients, that this is going to be a much more common thing, because in the old days you had the client on the phone from overseas. Now you can actually have the client effectively at the mediation, but virtually. So I think it's a good thing that's come out of it. I've had a couple of other hearings, and they have worked pretty well. The solicitors will be in one location or a set of different locations depending upon their preference. The barristers have sometimes been together, as in senior and junior counsel, and sometimes separately. I think it's better if the barristers are together, quite frankly. And the judge has been quite often in court. So you'll have a camera on the judge, and then whoever's talking, like with this session, will be you'll be able to see them pretty clearly. But you can also see the judge pretty clearly. And in fact, you're quite close to the judge, which means you're able to see the judge's reactions more easily than you would if you're further away, for example, in New South Wales, sitting behind the barristers, or in Victoria with your back to the judge. So it seems to work quite well. Maybe, Paul, if you could mention some of your experiences.
Yeah, look, they're very similar to yours. I agree that it can work well. And I certainly think that the courts will continue with a lot of the virtual aspects even after we get on top of the current situation. One point I would make, though, is that you really need to be very organised when you come to these hearings if you're talking about adjourning or trying to adjourn something, or wanting to depart from the sometimes even very strict court timetable, because the court will have expected you and the other party to really have thought about ways that the particular issues can be dealt with. So we've been dealing with an application for experimental evidence, for example, where we've had to work out the live streaming of those experiments because people can't attend, because people aren't able to travel, etc. Whereas normally you'd have people attend. Usually we wouldn't have witnesses wherever the experiments are going to be conducted necessarily. We'd get our witness to fly in, so we've had to proactively find other witnesses, etc. So it's not good enough for the parties to just say, look, it's all a bit difficult logistically. The court will really expect the parties to work things out, and it's only if it absolutely can't go ahead and there's going to be substantial injustice that they'll look at adjourning.
Yeah, I agree. You've got to be organised. You've got to have got the stuff up to the judge beforehand, or you've got to have it all queued up and ready to go with a shared screen so that the judge can see any material you want to give to her or him. So it does require a bit of thought, and it requires a bit of creativity. But there are trials going on. I think the idea of having the cross-examiner and the cross-examined in the room with the judge is a good idea, and you can basically have everybody else out of the room watching remotely. And I think the technology is working quite well, and certainly the resolution of the cameras is a hell of a lot better than it was even a few years ago. So it's a very good picture. So, and I think, quite frankly, we're probably going to be in this space where we're going to be having remote hearings, in my view, probably at least for the rest of the year to some extent, whether it is part of some people in the courtroom at one time or some people not in the courtroom. But I think we're probably there for at least the rest of the year. Yeah. So, Paul, did you have anything else to say before?
I agree with that, but I do think that there are good things that have come out of this, and that the process will incorporate the best bits of video conferencing going forward, and I think that'll sort of decrease costs and increase access to justice.
Yeah, video conferencing directions here might be one of them, which will save a lot of money. I should mention to people that if they have got a question or a comment, they can use the chat or the Q&A functions at the bottom of their screen to send along questions, and we'll try and answer them all at the end of the session. All right, well, I'll stop sharing my screen, and Rodney Davies is going to be going to provide the next presentation on issues in contracts from companies in financial distress and issues arising in IP licences, including licences for COVID-19 related technologies and compulsory licensing. Rodney.
Right. Thanks very much, Chris. Right, so in a fairly short time, there are a few things that I thought were worth mentioning in the context of current pandemic. And so all of these comments are really predicated against, or predicated or put into that context. So the four things that I was going to deal with briefly are hardship and force majeure clauses, force majeure clauses and their drafting, Crown use and compulsory licensing, and just some voluntary commitments that companies have made to try and improve the situation that we might otherwise have in relation to getting a solution to the current pandemic through medical relief, etc. So in relation to hardship and force majeure, the difference between the two is basically that a hardship clause generally covers a situation where performance has become more burdensome under the contract as a result of unforeseen circumstances, but is still possible. And generally, it leads to a continued performance, but perhaps on an altered basis. On the other hand, force majeure is generally applicable where performance has become impossible, and that usually leads to suspension or termination of the agreement. In Australia, there's no rule of law which introduces force majeure or hardship provisions into contracts, except contracts that are governed by or subject to the Vienna Convention for the international sale of goods. So in Australia, it's necessary for force majeure and hardship provisions to be expressly included. Now that's very different to many other countries, in particular civil law countries. So in France, for instance, in their civil code, there are provisions which introduce force majeure provisions. In Germany, their civil code deals with hardship or situations of hardship and introduces provisions which allow for the recasting of agreements to deal with those situations. China has both force majeure and hardship provisions in its legal system, and Japan, through the operation of a doctrine of good faith that they apply in contractual dealings, also has hardship provisions. So it's very important then to know what law applies to the particular contract in question, and that may well determine whether or not there are force majeure provisions which might apply in that particular situation. I also said that the only provision of a statute in Australia which introduces force majeure clause are contracts which are subject to the Vienna Convention relating to contracts for the international sale of goods. And that convention has been adopted by the Australian states and territories under their various pieces of legislation. And where there are contracts for the international sale of goods between between parties which are located in the member states or the signatories to the convention, then the Vienna Convention provisions will apply unless excluded. And for whatever reason, it's not uncommon for those provisions to be excluded in Australian contracts specifically. Be that as it may, there are laws in Australia which might affect the exercise of contractual provisions in the current circumstances. One of these would be the doctrine of frustration, which is a common law doctrine, but which has now been modified by a number of the states and territories in Australia, including Victoria. And generally, if performance of a contract has become impossible, then the legislation may well apply to cause the agreement to be brought to an end. And under the various pieces of legislation in the different states, it's possible that monies paid under a contract that's been frustrated can be repaid, or if benefits have been provided but not paid for, then the courts can award compensation. The other area which may well be of relevance to situations where parties are under particular hardship, or finding that there are the other party is trying to enforce obligations which are difficult to comply with, are contained in the Competition and Consumer Act. And in particular, there is a prohibition in that Act against people engaging in unconscionable conduct. And those rules apply in respect of business contracts as well. And so unconscionable conduct is something which is determined basically on society's values at the time as judged by the court. But there are also there is a lengthy list in the Act which deals with the criteria which the courts are to use in determining whether conduct is unconscionable. And in the slide pack, you'll see the numbers on the slide there, and they relate to some notes that you'll get together with the slides after the seminar is completed. The other provision of the Competition Consumer Act which may well be relevant is the prohibition on unfair contract terms, and the Act makes unfair contract terms unenforceable. Generally, these are in contracts that are of a standard form nature, and where obligations are not reasonably necessary to protect the legitimate interest of a particular party, and if enforced would cause detriment to the other. And so the Act actually sets out again a list of the types of provisions which will be prima facie regarded as being unfair and therefore unenforceable. Importantly, the unfair contracts prohibition also applies to small business contracts, which are those where one of the parties employs fewer than 20 people. The upfront price payable under the contract is less than $300,000, or if the contract has a life of more than 12 months, $1 million. So that would cover quite a large proportion, I would think, of business contracts. So the next issue I just wanted to cover were force majeure clauses in particular. And as I've said, these clauses must be expressly set out in a contract in Australia, but for those contracts which incorporate the provisions of the Vienna Convention. The wording of force majeure clause is obviously very important, and the first step is really to look at the obligations of the particular contract and the terms of the force majeure clause to see what types of obligations are likely to be, or the performance of which is likely to be excused by the clause. So for instance, it's quite difficult generally to argue that the payment of money is excused by a force majeure clause, because there are many ways to pay money, and the payment of the money is generally not made impossible by the particular circumstances that have arisen. So when drafting a force majeure clause, it's important to consider what sorts of obligations are intended to be protected by the clause, and what clauses might be affected by a force majeure circumstance. So clauses such as a most favoured nations clause, for instance, might be affected by a force majeure clause, and even an exclusivity clause might be affected if there's government intervention through compulsory licensing, say, which we'll come to later, arising in the particular event which is giving rise to the force majeure. So the sorts of clauses or obligations which might be excused in an agreement in the current situation would include sort of in-person training. I would imagine plant commissioning might be made more difficult or impossible. Inspection obligations, obviously. Attendance obligations, so in franchises, if franchisees are required to remain open during particular hours or have a particular number of people on site, then those obligations might not be able to be performed in light of the current restrictions that we face. And similarly, if production becomes impossible or unlawful because of government controls, then the supply obligation might be excused. So in summary then, I think where there's in the current situation, in order to determine how a contract should be carried out, it's necessary then to review the contractual provisions and identify the obligations which might lead to hardship, and see whether or not the contract contains a force majeure or a hardship clause which might deal with that situation. It's important to know what the applicable law is to see whether or not there are laws of the particular jurisdiction which might assist. It's important to assess whether or not those provisions either in the contract or which might be implied as a matter of law cover the obligations giving rise to hardship. And for parties or for contracts that are subject to Australian law, determine whether or not the doctrine of frustration might apply, or whether the Competition and Consumer Act might serve to qualify the exercise of rights and obligations under the contract through the prohibitions on unconscionable conduct or unfair contract terms. The next subject that I wish to deal with quickly was Crown use and compulsory licensing. And there are Crown use and compulsory licensing provisions in the various intellectual property statutes, but I'll just deal particularly with patents. So Crown use arises where the minister decides that it's in the public interest for the Crown to be able to exploit a particular patent. And so the Patents Act sets out the conditions under which that can occur. So the minister has to make a decision that a relevant public authority has tried for a reasonable period to obtain authorization to exploit an invention on reasonable terms, and is approved to exploit the invention. The invention is to be exploited for the services of the Crown or the particular authority, and the exploiting person is authorised, as I've said. Now, the important thing about the Crown use provisions as compared to compulsory licensing provisions is that the Crown use provisions apply both to inventions and granted patents, whereas the compulsory licensing provisions only apply to granted patents. So the Crown has rights to step in and use inventions before a patent is granted. And in terms of the criteria or the threshold that the minister has to be satisfied over, the idea that it has to be for the use of the Crown is very, very broad, and the Act makes it clear that something that is for the services of the Crown is something which the government, for the purposes of the government dealing with something that it has the primary responsibility or primarily funds. And so in the present situation, the federal government has a principal responsibility in relation to health services. So it's arguable that in the current pandemic, the Crown would have the right to step in and compulsorily use or acquire an invention or access to an invention. There are also special provisions dealing with emergencies, which aren't necessarily contained in the compulsory licensing provisions. So if the minister determines that there is a situation of emergency, then all of the details dealing with compensation and the like can be held over until after the Crown has acquired the right to use the particular invention or patent. So compulsory licensing is slightly different. It's a situation where somebody can apply to the court for a compulsory license, and there are two basic situations in which that can happen. Firstly, if a person can establish that demand in Australia for a patent invention is not being met on reasonable terms, there's no satisfactory reason for that being the case, the authorisation to obtain a licence is essential to meet the demand. There have been attempts to gain a licence on reasonable terms, but they've been unsuccessful, and that it's in the public interest to provide the applicant with a compulsory licence. Importantly, that application can only be made 3 years after the grant of the patent, and the licence, when it's granted, cannot be an exclusive licence, and the court determines the terms. So in the present situation, if we were talking about licences under patents which are only likely to be granted in the immediate future, then it's quite possible that the compulsory licence provisions wouldn't apply because of the 3-year requirement. Now, the second ground on which a compulsory licence can be granted is where the patentee has contravened or is contravening the Competition and Consumer Act in relation to its dealings with the particular patent in question. The Act also contains special provisions for compulsory licensing of pharmaceutical inventions for manufacture in Australia and export to an eligible importing country. And these provisions give effect to the Doha Declaration, to which Australia is a signatory, and allow a licence to be granted specifically for a pharmaceutical invention, again, not on an exclusive basis, but where the product concerned is necessary in an eligible importing country to address a public health concern. And so that would have particular relevance to the present situation. But again, it only relates to patents and not inventions. And in both of the types of compulsory licenses that I've dealt with, the person who becomes the licensor is entitled to reasonable compensation. It's the case that applications for compulsory licenses in Australia to date have been almost unheard of. There have been 1 or 2 in the last 100 years, I would say. Also, the idea that someone obtains a compulsory license in Australia to produce perhaps a vaccine or whatever that deals with COVID-19 is only a realistic proposition if there's adequate manufacturing capacity in Australia. And if there isn't that capacity, then it may be that Australia should be looking to apply for a compulsory license in a jurisdiction outside Australia where there is manufacturing capacity and where the country is another signatory to the Doha Declaration and has passed similar legislation to that which exists in Australia, so that the license granted would be for manufacture in that other jurisdiction and then export to Australia as an eligible importing country for the purposes of dealing with a health emergency. And then finally, notwithstanding all of these provisions for the compulsory acquisition or licensing of technologies, there are many situations around the world where companies have agreed unilaterally to make their technologies available. So, for instance, Gilead has signed non-exclusive voluntary licensing agreements with generic pharmaceutical manufacturers in Egypt, India and Pakistan to manufacture remdesivir for distribution in other countries. And these licensing agreements give the right on the part of the licensee companies to receive the technology from Gilead to enable them to scale up production, and then they can deal with the technology on a royalty-free basis until WHO declares the end of the current public health emergency, or until a pharmaceutical product other than remdesivir or a vaccine is approved to treat COVID-19. So that's just a voluntary decision by Gilead to make available its technology in the common interest. Gilead also has, incidentally, as I understand it, donated supplies of remdesivir to the Australian government, and I think there were 1 million doses. The next voluntary commitment that I just thought was worth mentioning is the COVID pledge. And this is a pledge which has been put together by scientists and lawyers. And under the pledge, companies agree to make their intellectual property available free of charge for use in ending the pandemic and minimising the impact of the disease. I think it was in May this year that the pledge was put together and launched. And there are a number of very large companies which have signed the pledge, so to speak. Microsoft, Facebook, Mitsubishi, Uber, I'm not sure what their contribution is, but anyway, and IBM. Interestingly, though, the people who have pledged their technology under the COVID pledge are mainly companies dealing with ancillary technology or services, so not really the actual companies that are developing or trying to develop vaccines or other pharmaceutical products to deal with COVID-19. There's also the COVID-19 Technology Access Pool, which has been put together by the World Health Organization, and that was released recently. And that's an initiative to ensure better access to existing and new COVID-19 health products through 5 priorities. And those priorities are the public disclosure of gene sequences and data, transparency of clinical data, tying research funding to making available of trial data, the licensing of related technologies to the United Nations Medicines Patent Pool, and the promotion of open innovation models and technology transfer. So that at the moment there are at least 40 countries and organisations which have joined the technology access pool, but interestingly or importantly, not the USA, Canada or Australia. So that was really all that I had to say on these 4 subjects. So I can just say thank you and stay safe, and I will now bow out of proceedings.
Good afternoon, everyone. My name's Jacqueline. I'm a law graduate here in the Melbourne office, and today I'm going to discuss the innovations that we've seen during the coronavirus disruption. There are 3 very interesting pieces of innovation that I'd like to talk about today. The first relates to the manufacturing of ventilators in Australia. The second involves the creation of clear patient hoods that have been used to protect hospital staff. And the last refers to touch-free door handles. So firstly, I thought I'd discuss how ventilators work. Sorry, my slides haven't appeared. Apologies, everyone. So I thought I'd start first by discussing how ventilators work. So these devices effectively breathe for patients who are experiencing severe respiratory symptoms. They function by pumping air to patients that's been enriched with oxygen, warmed and humidified, and it sends it down a tube into the patient's throat. The tube also allows the carbon dioxide to leave the lungs, and it applies continuous positive pressure to ensure that the air sacs of the lungs stay inflated. It's vitally important that we have sufficient numbers of these ventilators in order for patients to survive this crisis, particularly those who require hospitalisation. In a typical year, Australia sees roughly 160,000 ICU admissions, and it's expected that this year we will see another 90,000 admissions. In anticipation of this, it's vital that the state and federal governments have been able to increase the number of ventilators, and at the moment they're seeking to treble the number that we have at the moment. Unfortunately, worldwide demand has greatly exceeded supply, and so the Australian governments have sought to look for other ways of increasing our ventilator supplies. Firstly, they commissioned some ventilators from ResMed, a manufacturer in Western Sydney, but more are needed. This brings me to the NOTICE program, which is a consortium of Australian engineering and manufacturing companies led by Grey Innovation. Together, they've obtained a licence to use a design belonging to a UK company, and they've set about delegating tasks to the various members of the group. For example, the group CircuitWise has been making printed circuit boards for these ventilators, and Bosch Australia is manufacturing equipment to test those finished ventilators. The program received $500,000 in starter funding from the Victorian government, and it's received a further $31.3 million from the federal government. The aim is to produce 2,000 ventilators by the end of this month. However, when you have more than 30 companies working together to produce a common product, there's a significant risk that the companies may unknowingly engage in cartel conduct in contravention of Australian competition laws. The cartel conduct provisions of the Competition and Consumer Act include a prohibition on coordination of businesses in relation to market sharing, including the allocation of customers and the restriction of outputs. However, on March 25th, the ACCC granted an interim authorisation to allow parties to share information, coordinate orders, and jointly tender to supply COVID-19 medical equipment. Conditional authorisation has since been extended. However, authorisations don't occur automatically. The ACCC has discretion to authorise conduct that would otherwise breach competition law, but certain requirements must be met. Section 90, subsection 7 of the Competition and Consumer Act requires the ACCC to be satisfied either that the conduct would not substantially lessen competition or that it would benefit the public in a way that outweighs any detriment that could otherwise result. If either of these considerations can be made out, the ACCC can grant authorisation. It's quite likely that the notice program authorisation was permitted on the basis that the ACCC was satisfied that the production of additional ventilators would benefit the public far more than any detriment. In any event, given that only one other business was making ventilators in Australia and very few were being imported, The effect of the authorisation would be to increase competition and therefore would be unlikely to result in any detriment to the public. The other issue that arises for the notice program is the requirement for medical devices to be listed on the ARTG, the Australian Register of Therapeutic Goods, prior to their supply in Australia. However, where public health is threatened by an emergency, provisions of Part 4 of 6A of the TGA Act grant the Minister for Health the power to provide exemptions from these requirements, including where it's in the national interest to stockpile medical devices or to make them urgently available. The Minister has exercised this power and put out this exemption to ensure that ventilators, which are being manufactured in Australia but are not ARTG listed, can be lawfully supplied and used as needed. Whilst these ventilators are not required to be listed on the ARTG, the manufacturers can still comply with minimal technical requirements and other obligations, such as the mandatory reporting of any malfunctions. So that's one of the innovation areas that the government has been involved with, but the private sector and universities have also had a lot to do in this area. We know that hospital workers are at a greater risk of contracting COVID-19 from infected patients. And researchers at the University of Melbourne and Western Sydney have collaborated to develop a fully functional prototype for a portable ventilation hood that can effectively isolate a COVID-19 patient from medical staff. And it does so within a clear plastic shell. The goal of the device is to prevent the spread of infection. The hoods have been designed to capture droplets of fluids that have been expelled by patients through coughs and sneezes, while smaller particles that are liberated as patients breathe can be removed by a built-in high-efficiency particulate air filter. The hoods are effectively very large and penetrable clear masks that permit the medical staff to speak with and observe a patient safely, whilst minimising any contacts they have that could transmit the disease. The team has deliberately designed these hoods with low-cost components to make sure that they are accessible for hospitals in low to middle income countries. In the future, there is likely to be additional application of these with other infectious respiratory diseases such as tuberculosis. The last area of innovation is actually my favourite, and the reason for this is because it's so incredibly simple. So Welsh freelance designer Wyn Griffiths came up with this idea when he visited a hospital with his wife and noted that the COVID-19 might easily spread via contact with door handles. So the device that Wyn created clicks into place on a door and must be pulled open. It has a plastic arm that extends and hooks the person's forearm to it, allowing them to open the door without touching the handle with their hands. A similar device was created by another British man, Steve Brooks, who's a designer of office furniture. He thought about the concept that people use often their little finger or that tiny bit of the door that no one touches in an attempt to ensure that they don't pick up the COVID-19 disease from any contacts. So his design is this coat hanger style. And the idea is that each person has their own individual device, which hooks onto a door handle and allows it to be pulled open. This device is designed to be portable and contact-free, and that people should carry them around in their pockets and use them every time they come into contact with a door. So as the coronavirus continues to challenge Australians and others around the world, I hope that you all stay safe, and I look forward to future seminars with you guys in person. Over to you, Chris.
Thank you, Jacqueline. If anyone has got any questions, just while I'm wrapping up, could they, as I said, send them through on the chat or the Q&A, and we'll ask the panellists. Otherwise, at the conclusion of our session, tomorrow we will send out copies of the slides and some additional information on each of these topics to all of the attendees. And the sessions have been recorded so that people can watch them, recorded and placed on our website so that people can watch them if they want to, or they want to suggest to somebody else that they watch them. Were there any questions? I think that otherwise concludes our seminar. If I can put in a plug for a series of IP seminars and straight commercial law seminars we'll be running towards the end of next month. we'll be giving people details of those. And if there are any particular topics anyone would like us to talk about, we'd be very happy to address those topics. If anybody wants to email me or anyone anyone they know at DCC, we'd be happy to address those issues. So again, I'd like to thank everybody for attending, and I hope you all have a good night.